All right, hello and welcome to this evidence video capsule. In this video capsule, I'm going to be looking at the law governing litigation privilege. In an earlier capsule, I did some work on litigation privilege, but in this one, I want to look at the Supreme Court's most recent discussion of the matter, which is a case called Lizotte versus Aviva Insurance, a 2016 decision. It's one of the more significant cases from the Supreme Court of Canada on privilege. And I think it's important in forecasting how the law of litigation privilege is going to develop. So what I'm going to do is go through the case, and I'll finish with 4 questions that I think are important to the future of litigation privilege. So first, just a very quick primer and a reminder. A long time ago, the law concerning solicitor-client privilege and litigation privilege was split. It was thought, if you go back to some really early jurisprudence, that litigation privilege was a subset of solicitor-client privilege, and this was actually repeated by the courts on many occasions, but in Lizotte, the court makes clear that they are split. They are not the same thing. They have different purposes and rationales, even though they're kind of connected. There are some connections in that they both, to a certain extent, although they don't have to, they both involve lawyers. So it's really important to understand the differences between the two. Solicitor-client privilege, or legal advice privilege, or whatever you want to call it, is the strongest privilege we have. It's the hardest to pierce. And in the jurisprudence, for a long time, as the courts have been developing litigation privilege, one thing has been clear coming into Lizotte. It's a lesser privilege. It's not quite as strong as solicitor-client privilege, and the Supreme Court maintains that in Lizotte. But one thing comes very clear coming out of Lizotte: it's almost as strong. But first we need to understand exactly what it does. So here's a chart that sort of explains some of the difference between legal advisor's privilege and litigation privilege. And if you go and watch the capsule I prepared on litigation privilege, you know, that's a good primer into how this works. But to put it pretty clearly and as simply as I can, legal advisor's privilege is what I like to call a narrow privilege in its application, but a broad privilege in its strength. And litigation privilege is the opposite. Legal advisor's privilege is exceptionally narrow. It only covers communication between these people. So if a client speaks to their lawyer, or a lawyer speaks directly through an assistant, very direct communications, it's protected. But let's be clear, it's a very broad privilege once you are in this zone of relationships. Everything that takes place is protected so long as it was done for the purpose of obtaining legal advice. So a very strong privilege. Litigation privilege is different. Litigation privilege is designed to allow people to pursue their case in the strongest means possible. So it allows for a very broad class of relationship because there's a lot of ways in which you can pursue your litigative case. You can hire an investigator. The client can hire an investigator. To be very clear, there doesn't have to even be a lawyer-client relationship for litigation privilege to ensue. And it also covers things like lawyer or client preparatory work. So you're making notes for the case for yourself. Those are all protected by litigation privilege. So it is a broad class, but what I like to say is it's a narrower form of communication because it's harder to get into litigation privilege than it is in legal advice privilege. And what I mean by that is, with legal advice privilege, anything you say to a lawyer pretty much will be protected. There are some narrow exceptions to that, but it's really, as long as you're making a bona fide effort to get legal advice, they're not going to scrutinize very closely what it is you're saying or why you're going to the lawyer. It's usually in. But litigation privilege, because it deals with such a broad class of relationships, I mean, look, where the client's preparing things, that's incredibly broad. There is a key qualifier to what will fall into litigation privilege. And this is the biggest qualifier. It only applies where the material in question was prepared for the dominant purpose of real or apprehended litigation. That's a pretty big qualifier. It means that where you're doing things, if you're doing them for multiple purposes, it has to be the dominant purpose is real litigation. Anything else that you prepare something for, if it's for any other reason, it is not protected by the privilege. So not quite as strong, but let's be clear. This does cover a wide swath of information contesting litigation privilege claims, very, very common in the lower courts. So Lizotte versus Aviva Insurance helps to clarify some very important issues about the strength of this privilege. So in Lizotte versus Aviva Insurance, the Supreme Court deals with what I'm going to list as, I think they deal clearly with 5 issues, and I think they raise a couple of more that they don't deal with quite as clearly. But 5 questions are very clearly addressed, and all 5 of these questions have been things that have been problematic lurking around in the lower courts about, what is the status of this particular privilege. And here is question 1, and I should probably point out that it's Justice Gascon writing for a unanimous Supreme Court. So there's no dissent here, no one disagrees on the basic confines of the privilege. Is it a class privilege or a case-by-case privilege? Now, if this confuses you, let's just say that the court long ago split all privileges down the middle. There are class privileges, of which we recognize solicitor-client privilege, police informant privilege, there are a bunch of others, spousal communication privilege. These are what are called class privileges. Or is it a case-by-case privilege that is only recognized in certain circumstances? And that is the classic, for any of you familiar with the law of evidence, the classic Wigmore test, which, to make a long story short, is essentially a balance. Does the interest in upholding the privilege outweigh the interest in piercing it? There are some other criteria, but that's the basics of it. And let's just say that anybody who wants to defend litigation privilege wants it to be a class privilege because it's much harder to get in. Essentially, a case-by-case privilege, a Wigmore-based privilege, is really hard to defend because it's only going to apply in certain circumstances. In other words, do we have to, every time there's a claim of litigation privilege, consider on a case-by-case basis whether it should be upheld? And the court says no. The court says this is a class privilege. And I think this was the easiest decision for the case to reach. There were some cases in the lower courts that indicated that this was a case-by-case privilege, but I never bought them. The whole idea of a class privilege is that it's a recognized area, right, that deserves to be protected because it's been recognized over time. And that is undoubtedly true for litigation privilege, which is why you end up with a presumption of inadmissibility instead of deciding it on a case-by-case basis. I should point out that I'm not a big fan of case-by-case privileges for the most part. In fact, I think the Wigmore privilege test is problematic, and I wish the court would recognize more class privileges. The irony is that the court said in another case, National Post Incorporated versus the Queen, that they were going to be much more judicious about recognizing class privileges, if ever, which I think is a mistake by the court, but that would take me off into a whole other video blog. Let's just say I applaud the decision in this case. No big problem here. It is a class privilege. Now, the court also dealt with a related question, which said, okay, it is a class privilege, but is there a general exception to the litigation privilege where the harm clearly outweighs the benefit? And this is not quite the same question. It is slightly different because, of course, it switches the onus around. That's all it really does. And effectively, think about what I said earlier, class versus case-by-case. In a case-by-case privilege, the person propounding the privilege who says, I have this information, it should be protected from disclosure. The onus is on them to convince the court that the privilege should be upheld. Well, with an exception, it's different. The court recognizes that the material does fall into the privilege, it is protected, but the other side can get the material if they can show the harm outweighs the benefit. And this is not a crazy idea. In fact, it's been lurking around the jurisprudence for a long time. In a case called, a very famous privilege case called Shrews, Justice Doherty wrote a lengthy dissenting opinion saying there should be a general exception to litigation privilege for a lot of good reasons I'm going to explore later on in this podcast. But at the end of the day, he was overruled in the Court of Appeal, and this was many, many years ago in the 90s, and Justice Doherty lost again here. Essentially, the court sided, literally taking word for word, the decision of Justice Rosenberg in the Court of Appeal decision in Shrews many, many years ago, saying no, a balancing test would lead to unnecessary uncertainty and a proliferation of pretrial motions. So essentially, the idea that there is a general exception to litigation privilege is kiboshed in this case. But the court goes on to address another question. Can new exceptions be recognized? And that's an interesting question because when you're dealing with solicitor-client privilege, the courts have been absolutely clear that exceptions are very rare and new ones are almost never created because the privilege is so strong. But here the court sort of leaves an opening. effectively recognizing that litigation privilege is not as strong and not as important a privilege as solicitor-client privilege. And they say, yes, new exceptions can be recognized as long as they apply in specific circumstances. So again, what the court was worried about here was that certainty and avoiding litigation that they talked about earlier. They even recognized that there might be an exception based on urgency and necessity. And what they meant by that was the problem with litigation privilege is that litigation privilege is not a permanent privilege. It essentially delays the ability of other parties to get the material in question. And the court recognized that there could be situations in which urgent need overrules the privilege, but they declined to decide it in this particular case. Okay, does the privilege apply against third parties? That was another question decided here. And what this means is very simple. The argument essentially by the insurer was that, the assurance regulator, was that A and B are engaged in litigation, and A has material that's protected by litigation privilege. The idea is that A can surely shield at all times. The privilege acts to shield access attempts by B. But what about C, who has nothing to do with this litigation? And essentially that was the argument of the regulator here. I'm not interested in the A versus B problem. I want to get at the material for another valid purpose, C. Now, I don't think this one was as controversial as some of the others because, to be honest, the British Columbia Court of Appeal just dealt with a very, very similar case. And they decided the same thing the Supreme Court of Canada did. Yes, it applies against third parties, and I think that's absolutely sensible, though as I'll show you in a bit, I think there could be a problematic situation, but I think it's very, very sensible. I don't think it matters. If A and B are engaged in litigation, I don't see why C should be able to pierce around the privilege and get the information for their own purposes. Ultimately, that risks losing the material and the privacy in that material to potentially B's advantage, and I don't think that's what the privilege was designed to do. And the court canvassed the idea of putting up various protections and ways to prevent C from disclosing and just said, look, it's too complicated. It's a class privilege. Allow A to do what they want without any fear of anybody. So it's a universal shield against all parties. And the final very interesting question in this case is how do we treat statutory abrogations of the privilege? The reason why this is a question is to overcome solicitor-client privilege, the court has said that you need very clear language, like really clear. It's got to be literally a takeaway of privileges and solicitor-client privilege before the statute will be allowed to overcome the privilege. So basic statutory provisions that allow for disclosure are not enough to overcome the privilege. There has been a school of thought lurking through the jurisprudence that litigation privilege is a less serious privilege than solicitor-client privilege and shouldn't be treated in quite the same way. And the Supreme Court blew that out of the water too. In what may have been the most surprising part of the decision, they said statutory abrogations should be treated in exactly the same way. To get rid of litigation privilege, the statute has to very, very clearly do so. Not unprecedented, definitely a decision that, in fact, the whole decision elevates litigation privilege and says, no, this is an absolutely critical privilege, don't treat it lightly. Which leads us to some questions. So I have 4 big questions about the decision, and these are not really critiques, they're just questions. And I guess my first question is, will the court come to regret not recognizing a general exception? The reason for that is simple. Justice Doherty, in my opinion, in the Shrews case, was on to something, in that he recognized that litigation privilege has the potential to be a big problem. Here's why. Litigation privilege often protects the very best evidence in a case. What I mean by that is, I'll give you the classic case that I always use to explain this, which is the railway case where litigation privilege was first really recognized in the UK. And there was a railway accident. And essentially in that accident, a car was derailed and a lot of people were injured, died, and there was a lot of damage. And what happened is the railways went out and sent out an investigator. And the investigator collected the absolute best information relating to the case. And then the railway, when it was sued, wanted to protect that, saying it was protected by litigation privilege. And the House of Lords got around this problem by saying, well, the dominant purpose was not litigation. When they sent out the investigator, they were trying to find out what happened, they were trying to prevent future railway accidents, blah, blah, blah. The problem is that there is a lot of ways to manipulate the dominant purpose test. And the idea is, Justice Doherty and other theorists have said, better to be honest and just recognize a general exception rather than manipulate the dominant purpose test. Because the truth of the matter is, there will be cases in which somebody is going for litigation purposes and they get the best or perhaps the only evidence. They investigate something right after it happens and get absolutely critical, crystal clear evidence of something important, and then it is buried by litigation privilege, and that is not in the interests of justice to allow that to happen. So the idea is that Justice Doherty recognized if we have a general exception where the interest in privilege is clearly outweighed by the need to get that information, then the courts are protected because we can get at the best evidence of the case. Instead, what we're left with here, and I've seen a lot of cases like this, where it's amazing how the courts manipulate the dominant purpose test, or another aspect of the test, the end of litigation test, to allow piercing of the privilege. So I think the court one day may come to regret this, but maybe I'm wrong. It's an interesting question to think about. This is a sneaky problem that's going to arise in the years to come, and it's really interesting. Paragraph 49, for those of you interested in litigation privilege, is one that needs to be read. There have been a lot of questions about how the rules on waiver apply to litigation privilege, and let's just be clear. When we're dealing with solicitor-client privilege, waiver in the context of keeping the material private is very easy to deal with. Essentially, the lawyer and the client have to keep the information private. But in litigation privilege, that's a lot harder to do because the nature of who's investigating takes it out of the hands of the lawyer and the client. So essentially what happens is other people get their hands on this information for various reasons, and the question then comes whether or not it's waived. And in paragraph 49, the court seemed to endorse a few lower court decisions which are hardly universal on this subject that suggest that where you disclose something to a third party, it results in a waiver against all parties. And it's not quite clear that that should be the case with litigation privilege, and it's really interesting looking forward to know how the courts will approach waiver in the context of litigation privilege. Did the court signal in this decision its express approval, or at least its implicit approval, for a broad waiver rule? Very interesting for litigators to consider going forward. A third big question is how will the courts address criminal investigations that want to get at material protected by litigation privilege? There's a very interesting case out of Manitoba from years ago called Bidzinski. And in Bidniski, sorry, I've misspelled it here. What's interesting about that case is you have an assault that takes place, a big assault takes place in a bar, and essentially it's investigated by the bar, and the material that comes out of that is then protected. But the police come along later and want that information. And the judge holds that they can have that information because litigation privilege only applies to the parties. Sound familiar? Well, the reason it sounds familiar is because that's no longer good law. The idea that litigation protects only to the parties is not good law anymore. So it is protected against the police. And I guess the question that arises here is whether or not the police should have access to the material, because I believe that they should. I think there needs to be room to create what's probably going to happen is some sort of exception. And my guess is one way of dealing with that is that urgency and necessity exception that the court was sort of thinking about in allowing the police to properly investigate matters. But this is going to be an area of tension going forward, because what the court has said in this case is that litigation privilege is important. It needs to be protected. It will be interesting to see how that takes place when the two interests clash. Now, for my money, this is the biggest question lurking in litigation privilege. It's amazing it's been going on for this long, and I'll explain it very quickly as to what it means. Litigation privilege is a privilege that is technically protects documents. It doesn't actually protect information per se. It just says you don't have to disclose that information because it's kept private. But what does this mean? Because in Ontario, what happens in Ontario is that litigation privilege documents have to be disclosed generally, in the sense that you have something that's protected by litigation privilege in what's called an affidavit of documents. And then what happens next is, when a party is discovered, they are then asked about the information in the litigation privilege. And because the courts in Ontario have held that litigation privilege does not protect the information, only the documents, they have held that you have to answer questions about discovery. And where this has emerged, just to put this in very concrete terms, is in the area of surveillance. So A is suing B for personal injury. And B hires a private investigator. And that private investigator goes out and surveils A and says, wait, they're not really that injured. I have all this great information. I'm going to use it against them at trial. They then claim this as privileged. And they hold the surveillance back and say, well, we're not going to disclose it to you because we're going to use it when A gets up and testifies and says that he was injured. We're going to then cross-examine them using all the surveillance and absolutely devastate their case. Well, in Ontario, the courts have held that's unacceptable because what the courts have said is, yes, the private investigator's report is privileged. Yes, I agree with that. But on discovery, the party can be asked about any surveillance and have to answer because the privilege is not substantive. And essentially what they say is that the rules of discovery have overrode this exception, have overrode the privilege in this circumstance. I'm not so sure that holds anymore. In other provinces, the courts have held, no, that is absolutely incorrect. The basic idea that the claim can be overridden by generalized rules saying you have to answer questions on discovery is flawed. The privilege is stronger than that. And frankly, I think those cases are bolstered by this case in Lizotte. And it's going to be really interesting, given how many important litigation privilege cases come through in Ontario, to see how the Ontario courts deal with it. It wouldn't surprise me, and frankly, I would really like to see litigators take a run at this jurisprudence, which has been upheld by the Ontario Court of Appeal on multiple occasions. So what does this mean for this particular exception in Ontario? Well, that's a lot about the case of Lizotte versus Aviva Insurance, and I hope that was interesting to you. Have a great day. To learn more about this topic, you might want to check out my book, The Law of Witnesses and Evidence in Canada, published by Thomson Reuters. This book covers every topic involving the law of evidence and also how witnesses come before courts and tribunals in criminal, civil, and administrative proceedings. To learn more, you can check out my website at petersankoff.com.